this session. Welcome everyone to the panel discussion on the future of affirmative action in higher education. My name is Lori Slaughter, and I have the honor to serve as the first executive director of ARCS Foundation Oregon, a woman-founded, woman-led nonprofit that will celebrate its 20th anniversary next year. The women of ARCS are exceptional. They come from all walks of life and have dedicated their time, talent, and treasure to a shared mission of advancing STEM education in our state. I believe that two of our founders are with us today, Ellen Richardson and Nancy Fisher, and many of our board members and volunteers are as well. One of our board members is joining us from Turkey today while she's on vacation. So that's real dedication that you see in our ARCS members. I want to thank all of our ARCS members for your leadership and continued support. It's a pleasure to work alongside of you to deliver on our mission. At ARCS, we believe STEM research will uncover solutions to our world's most challenging problems, and it's our singular mission to support the next generation of promising STEM scientists right here in our state. We provide unrestricted financial awards to PhD students in a variety of STEM fields, and we do this in partnership with staff and leaders from Oregon Health and Science University, Oregon State University, and the University of Oregon. Our awards allow scholars the flexibility to cover academic or personal expenses as best suits their needs and helps them focus on furthering their research. Our scholars are the physicians, scientists, entrepreneurs, professors, and engineers of tomorrow. They accelerate research every day and bring new ideas to problem solving. ARCS Foundation is deeply committed to inclusive excellence as a core value critical to science and innovation. We believe that diverse perspectives are necessary to develop solutions to the complex problems we face today. So naturally, our community wanted to learn more about the impact the recent Supreme Court ruling might have on our students, partner universities, and STEM in general. To that end, we are delighted to bring together this panel of experts to share their perspectives on this important topic. Before we get started, I'd like to thank Penny, Scott, Emily, and Kristen for generously giving their time today and for sharing their insights and knowledge with all of us. I'd also like to thank Senior Director of Development at the OHSU Foundation and ARCS board member Jamie Brown, as well as Development Associate of ARCS Foundation, Alex Blackwell, for their help in making today's discussion possible. We're recording this session and we'll share this link or share a link to it with you all in a few days. If you do have questions for the panel, please use the Q&A feature in Zoom, and we'll do our best to get those questions addressed toward the end of our discussion. Now I'd like to turn it over to Kristen Watkins from the OSU Foundation, who will be moderating our today's conversation.
Thank you so much, Lori. It is my pleasure to join you all this morning and to be the moderator for today's panel. As Lori said, I'm Kristen Watkins. I am the Vice President for Donor Engagement at the Oregon State University Foundation. As many of you on the webinar know, OSU is our state's largest university. It's also our statewide university with locations in all 36 counties and a very robust e-campus program. We're very proud of the widespread access to higher education that we offer residents of our state, as well as the widespread application of research to our communities throughout the state. The foundation at OSU inspires philanthropic and volunteer support for the university. I have been with the foundation for about 9 years. My role includes a number of different functions, but one of the areas that I oversee is our efforts to work with donors, the university, and our legal counsel to design philanthropic gift agreements that meet the intent of our donors, meet the goals of the university, and also fit within any legal parameters. Couple of facts about me. I have been an ARCS member since I think 2015, and I'm currently a doctoral candidate at Oregon State. And my research is really focused on the role of philanthropy in shaping student success and equity in higher education. So I'm really, really pleased to be a part of the group this morning. I'm going to now ask our panelists to introduce themselves, and we'll start with Penny Serurier.
Hello, everyone. Thanks for being here, and thank you for inviting me to speak. I'm a partner at the Stoll Reeves Law Firm in Portland and a proud ARCS member. I think I have been a member since not quite the beginning, but about the first class. So love the organization and the great work that ARCS does. It's very inspiring. My law practice is in the area of nonprofit organizations. I represent nonprofits of all different shapes and sizes, from advocacy organizations up through education and a little bit of healthcare even. My focus is really around higher education, representing both public and private institutions and the organizations that fundraise for them. As well as a focus of my practice is large foundation work, so grant-making organizations. Again, happy to be here, and I'm going to turn it over to Scott.
Thank you. Thank you so much for the opportunity to be here. I'm very excited for this panel. We have some wonderful panelists and a great moderator. My name is Scott Vigneault. I serve as the Vice President and Chief Diversity Officer at Oregon State University. I've been serving in this role both in an interim and permanent capacity for a little over 2 years, and I've been at Oregon State for 8. And this is a wonderful topic for us to discuss, and I'm glad to be here. Thank you.
And my name is Emily Schultz. I am Deputy General Counsel at OHSU. I have been in legal counsel for, I believe, going on 8, and in this role for 2 to 3. Time flies. I'm very appreciative of the opportunity to come here today. I work on a lot of student issues, including the impacts to our admissions process and how we are continuing to fulfill our mission of educating a diverse spectrum of healthcare researchers and providers against a legal landscape that's progressively more challenging. So I appreciate the opportunity and look forward to hearing from you all and the other panelists.
Thank you, Emily, Scott, and Penny. Well, we are looking forward to a robust dialogue. To kick us off, I'm going to ask Penny to set some context for us. You know, in late June, we all know that the Supreme Court ruled in 2 cases that were brought against Harvard and the University of North Carolina. At issue were their admissions policies, and in particular, the way that they deployed race as a considerating factor in those admissions processes. The court ruled against Harvard and UNC, changing direction of decades of case law that did permit some consideration of race, among other factors, in admissions decisions. Penny, can you unpack that decision for us a bit, those 2 decisions? What do they mean? What are their implications? What university practices and policies did they cover, for example?
Yeah, great. I'm going to start actually by sharing my screen. I have a couple of slides that hopefully will help us set the stage for what's can be a very complicated conversation. So let me just get my bearings here. Okay, thanks for your patience. Can you all see just the slide that says the future of affirmative action in higher education?
We can.
Excellent. A bit of an ambitious title. I was actually tempted to boil 50 years of constitutional law down to 5 minutes. And instead, I thought that would be a little crazy. So I thought I would do two things. First, address at a very high level the decision itself and give you a couple of takeaways from that. And then second, take a quick look at the legal landscape that affects any organization that is implementing, I guess I would call it, a race-conscious decisions or programs. So first of all, the decision, as Kristen said, came down in June. Two different schools with different admissions programs. Harvard, of course, is a private university. University of North Carolina is a public university. The Supreme Court, or somewhere along the process, the cases were consolidated. So the court heard both cases and issued one ruling. The ruling, of course, the holding is right there on the slide, that the court concluded that the race-conscious admissions programs, even though they were slightly different programs, the programs implemented by both schools violated the Equal Protection Clause of the U.S. Constitution and Title VI of the Civil Rights Act of 1964. So a couple of takeaways about the decision itself. There is a window still. The majority opinion wrote that nothing in the opinion should be construed as prohibiting universities from considering how race may have affected an applicant's life experience. So what did change, however, is the Grutter decision, which happened maybe a decade earlier, had specifically allowed admissions programs to take race into consideration as a plus factor in a limited context. So that went out the window, and instead we do have still some room to consider race in the admissions context, but much more narrow. I also want to point out that the decision itself applies only to college admissions. It does not apply to all of the other things that our universities are doing to increase and support diverse students. Scholarships, student centers, student support, student groups that might be race conscious or race focused. All of those are still in effect and aren't necessarily directly affected by this decision. So that's a very important takeaway. And then my final takeaway about the decision itself is that it actually took 9 years to work its way through the system from the time that the first complaint was filed by SFFA. That's a takeaway in the sense that we expect further challenges outside of the admissions context, but those challenges are going to take a long time to work their way through the system, up through the Court of Appeals, and then ultimately perhaps we'll have another Supreme Court decision. So the second high-level look I wanted to give you is the legal landscape that affects these decisions overall. So again, any organization that is implementing or making decisions that are race conscious, everyone essentially has to consider the context. In this slide, I'm going to spare you. I'm not going to go through all of these elements, but depending on the factors, they may or may not apply to specific organizations. The two red asterisks that you see are what the court relied on in ruling that the admissions programs at issues violated both the Equal Protection Clause and the Civil Rights Act. Technically, the Equal Protection Clause did not apply to Harvard because the Equal Protection Clause applies only to public entities, and Harvard is a private entity. The Civil Rights Act applies to any entity that receives federal funding. And so early in the decision, the court dropped a footnote that essentially said, we acknowledge that the Equal Protection Clause does not apply to Harvard. However, both institutions are subject to Title VI of the Civil Rights Act. and we're going to basically treat them the same. I think constitutional scholars have taken some issue with that because the historic analysis under the Equal Protection Clause and the Civil Rights Act has been slightly different. But the court went ahead and said, what we're talking about applies equally to both entities because we're focusing on essentially the Civil Rights Act in Title VI. As you see from the slide, the other consideration that we all have are laws that come into play from other areas, not just the two with the asterisks. In particular, state laws can restrict what colleges and universities do in this area. Some states, as many of you probably know, have their own legislation or statutes that have passed that restrict their state schools from considering race in admissions and other contexts. So my final slide, overall takeaways, before we turn it back to kind of, I view Scott and Emily as the two who are really engaging with this issue and figuring out in a practical sense what universities can do or can't do. So before we move to that practical implementation post Supreme Court decision, these 3 or 4 points are just other takeaways I want to leave you with. First, it's really important when you're looking at any actor, any situation, to first determine whether federal funds are involved. Because if an organization receives federal funding, then we have triggered this strict scrutiny analysis that the court went through in the SFFA decision. Many entities out there that support students, administer scholarships, are not public entities and do not receive public funding. That said, virtually every college or university in the country, public or private, does receive federal funds. So universities, by their action, will trigger strict scrutiny for race-conscious decisions, or could, whereas an independent private foundation, for example, that is making scholarship grants can continue to do so in a race-conscious way without being subject to the laws that the Supreme Court discussed in its decision. Just quickly, again, admissions only was considered in this opinion, and so arguably all of our DEI programs and other race-conscious protocols are not yet prohibited. And overall, the big picture takeaway, and this is again, Scott and Emily, colleges really do have to pay close attention to how they are using race and ethnicity in these other programs outside of admissions, because it is very likely, if not very possible, if not likely, that we're going to see some more challenges from organizations like SFFA. And the bottom line is, in these large gray zones that we're working with, it really is almost a business decision on the part of the college to engage in different levels of race-conscious support for students, because the legal landscape at least, is still such an unknown. And I'll just leave with a parting thought for at least this portion, that there still is a lot of great work that can be done in a way that supports our students with diverse backgrounds. So with that, I'm going to stop my screen share. Hopefully this gets us back to where we were. Are we back there?
We are. Thank you so much, Penny, for that overview of the ruling and the relevant legal landscape. All right, so let's talk a little bit more about what we think the implications of this ruling is. So, Scott, Emily, what do you think the implications of the ruling are for higher education writ large? But then also, if you could talk about it for each of your institutions as well. Scott, would you kick us off?
Yeah, sure thing. And Penny, thank you so much for that really incredible overview. I think it's really helpful to start with what the case actually says and what it doesn't say, because my my sense of the conversation around the SFFA cases is that there are some conclusions that are being drawn from those cases that aren't actually articulated in the ruling itself, and that is really, really important to be clear on what we're actually talking about. So, what are we talking about? As Penny mentioned, this is an admissions case, and while it is certainly instructive in lots of other domains related to how we advance equity goals, at its heart, it is an admissions case. And the other thing that it did is that it did not say we can't consider the experience of our students that may have been mediated by race. And that also is very, very important. And so as we're thinking about this case and its potential impact, something that I think is important is to work, especially with your general counsel, to understand what's in and what's out, and to be very thoughtful about not overreacting to the ruling itself. That is something that I think I've certainly heard from community members at OSU, that their takeaway is, well, we can't do this anymore. We can't do that anymore. These sorts of programs will necessarily have to disappear. And my response in those circumstances have been, that's not, I can understand why you feel that way. And let's actually talk about what the case says so that we can make wise decisions that position ourselves for success in the future as it relates to advancing our DEI goals. So one thing that I'll just briefly comment on is, particularly if we think about admissions, that this is a case that mostly affects institutions that are selective by nature. So for every one spot, they have 12 excellent applicants, and they're looking to make decisions in a very limited way prior to SFFA by considering race. That's why we're calling it a race conscious admissions as opposed to affirmative action. That tool has been removed, but for many institutions like OSU, we have at our heart of our mission an access mission, and so we are not in a position where we're denying applicants because as a land grant, as the statewide, our goal is actually to admit all qualified students that come to OSU as applicants. And so we've never used race in our admission processes. However, that doesn't mean that we shouldn't be thinking about how to diversify our student bodies. And here is where I think there's a lot of alignment between selective institutions and institutions like OSU is thinking very clearly about how we develop pathways for students, starting when they're youth, moving through high school, and then when they're entering college, and graduate school, in fact, that there is a lot of work to be done in that area that is race neutral, but very focused on the kinds of barriers that we know some students and their families are facing as they pursue higher education. And so that is a pivot in some cases away from using race as a consideration to actually a more holistic view of admissions that considers how students find themselves along the path to reach our institutions. And so I'm actually, in some ways, I am not grateful for this case, but I am grateful for the context that I think it has provided to some of our institutions to think more broadly about how we do our work in ways that are more sustainable.
Thanks, Scott. There's a couple of things that you mentioned that I want to pick up on. I mean, one is, I think the focus of this case, and really, you know, most of these cases are being brought against private universities or elite public universities or graduate schools, right? Where the competition is fierce to get in. And the reality of it is that the vast majority of our students of color and other underrepresented students are educated in our state universities, our public access institutions, our community colleges across the country. So there's a bit of I think a dichotomy there that you highlight. The other is, could you say a little bit more about what it might look like to think about and consider a student's experiences that have been mediated by race versus the inclusion of race or ethnicity specifically in these processes?
Yeah, sure. So I think, at the point of admission and what that has looked like, I think for a lot of institutions is more of a focus on as you mentioned, a student's experience. So if they have encountered certain barriers to accessing higher education, an essay, for example, is a good place to talk about what that looks like. And in the wake of SFFA, many elite institutions or selective institutions have actually developed essay questions that are allowing for that kind of analysis to take place at the time of admission. Now, the challenge there, I think, is that one, I am concerned at times that is a practice that will also be challenged, and I think that it will need to be a lot of thought and care paid to the actual process of analyzing those kinds of essay questions and the responses to those essay questions. And then I also think there's a lot of clarity that needs to be provided to students, that this is not a backdoor asking you to just tell us your race through an essay question. We are actually asking for more, for consideration of what that experience has been like. And that the other thing here, I think, is that it also provides, on the upside, an opportunity for universities to think about students as complex, full people. So it's not just race, it's economic circumstances, it's where they grew up, it is the kinds of things that they've learned over the course of their educational journey. And so designing these questions, I think, is really important. And then the last thing I'll say about this is making sure that you have staff and resources to actually give the attention to these questions, the responses to these questions that are needed. It takes longer. It is more effort, particularly if we're doing a good job. And so my other concern is that one area is that we're asking these questions, but nothing else about the admission process has changed. Well, then I think it opens us to potentially a challenge to say, well, then you're just doing things the same way that you've always done them. And so documenting sort of from a process standpoint of how the admissions flow has changed is actually really essential.
Thank you. Emily, would love to hear from you about your reflections on the ruling, and then specifically what are the implications for Oregon Health and Science University?
Absolutely. Thank you. I echo lots of Scott's comments. I would say my first big takeaway is sort of don't panic. It really is a pretty narrow ruling. It says you can't use race-based assumptions in admissions decisions. Now, I agree with everything Scott said in terms it will absolutely be more applied more broadly than that. Penny gave a really good overview for how those things will be used in sort of concentric circles. I think it is a clear signal that the court and subsequent lower courts will interpret a lot of the strict scrutiny race analyses to prohibit this in employment decisions, in the administration of scholarships, in lots of things that are super relevant, right, to our respective organizations. And so we would be foolish not to be thinking about all of those things in the context of this decision. But we absolutely can continue to use race data to measure our goals, to measure our progress towards those goals. We can you don't, it isn't, it is important to not pendulum swing the other way, I guess, is sort of my main takeaway. And I am proud of OHSU's leadership. And I know OSU is the same, that we have reaffirmed our commitment to racial diversity and lots of other diversity, right? So I would say that's sort of the number one thing. That I have distilled it down to a little bit of a very simplistic analogy, but it kind of helps in some of these conversations for folks who don't have a ton of familiarity or haven't read the case. That really, in my mind, what the court did with and I will hold my thoughts on whether this is a good use of the court's time for the end, but is prohibit race-based assumptions. So you have to assume in admissions decisions or any other type of decision that one of your applicants is a Black applicant who grew up in Manhattan in a very economically and socially privileged environment, who maybe never experienced any type of inequity that is associated with their race. I think that is a very unlikely assumption, but it is theoretically possible. And what the court said is you can't extrapolate or make assumptions about an applicant's lived experiences on the sole basis of their race. And while I think that is very tone deaf of the court at this point in America, I still don't think that's a bad thing. I mean, I echo Scott's. Scott sort of said, "Hey, there are some pieces of this that we can be grateful for." I probably won't go as far as grateful, but I will say I don't think it's a bad thing to be thoughtful and nuanced about what actually about our mission we are looking to incentivize, what mission-based factors, whether that is recruiting, prioritizing, and fostering healthcare providers who have direct experience with healthcare inequity. Whether that be racial, economic, rural, something else, and how we're going to recruit those folks, how we're going to foster them, and how we're going to make sure that they end up becoming the scientists and researchers and healthcare providers that are going to serve OHSU or OSU or any other organization's specific mission. I mean, I'm speaking to some of OHSU's mission and the thought that we've put around and how, what specific things we really are looking to enrich our classes with, right? And to produce the healthcare providers and scientists of tomorrow's Oregon. And so on that level, I do think it's driving us to better articulate what mission-driven factors we're looking to incentivize, and then align our processes to do that. And I'll pause there. I'm sure there are more questions coming about how we have done that, but I appreciate hearing other folks' thoughts.
Thanks so much, Emily. Scott and Emily, you both mentioned perhaps some fear, concern within the campus community about the potentially far-reaching implications of the ruling. Could you comment a bit on what you're doing to communicate with your campus communities to help them understand, to allay concerns, perhaps?
Sure, I'm glad to address that first. So I think for us, our strategy has been, frankly, a lot of one-on-one conversations. And this is one of those topics that I think you can write an email and be crystal clear, and you won't necessarily diffuse, I think, or dissipate some of the fears that folks are feeling. And one thing I don't want to downplay is the real impact this has on people's sense that of belonging, frankly. The message that I think the court implicitly sent is, we shouldn't be considering race-based assumptions, as Emily put it, when the reality is that race mediates many aspects of a student's experience at an institution. And so for us, the strategy has been sitting down with folks that are running programs, with our enrollment management partners, with faculty who are trying to make decisions about graduate admissions, to actually talk about here's what this ruling means, and let's talk about what you're doing that to make sure that we're in line with the decision, but also thinking creatively about what else might be possible. So I will share, because OSU has not used race in its admission decisions, it's actually opened up some additional doors for us to say, and also, have you considered all of these other things that you could be doing when it comes to, let's say, pathway development or community engagement, or thinking about including parents and families in these conversations, and so forth. And so we're trying to put kind of a positive spin on a challenging ruling, to create opportunities for new ways of thinking about advancing our goals.
Emily, what about at OHSU?
Yeah. So thank you for that, Scott. I think you brought up something that's really important, which is the impact on individual students or DEI, officers who have worked really hard on these issues, and how this ruling really did negatively impact even our students of color sort of sense of whether or not they really belonged here or not. So the provost has been extremely proactive in communications with students. That's not really my role. I have partnered with the provost, and my office has partnered in having, I jokingly call it a roadshow, but a little bit like this, right? A series of panels and sort of panel adjacent to our normal DEI efforts, our admissions cycles, our we've presented, we have a big initiative, 30-30-30, which is to increase diversity across a number of spectrums, socioeconomic, rural, disability, public assistance, race. And so it has dovetailed pretty nicely into, hey, how are we measuring those things? How are we defining those things? How are we talking about those things? And then how are we eliciting the appropriate information out of our applicants that isn't, check a box race-based? How are we asking about applicants' lived experiences in a way that's going to allow us to evaluate them really holistically? So certainly, some of that is one-on-one. I would say in my role, I have probably done it in more of talking with groups of individuals who are really working really directly on these issues. Certainly our admissions committees for each of the schools, and talking about the key points about what we should and shouldn't have in our admission cycles and our processes, how to make sure that race data is sort of segregated from admissions committees. And those are in general the conversations. Of course, we've been like I said earlier, we've been having broader conversations too. How do we make resident and fellow selections, even though that's an employment decision, but how are we doing that in a way that is sort of still consistent with this decision? What about scholarships? What about, and so I think those conversations have been happening all over the map for us. And part of that is a reaction because this was a really disappointing decision. And so folks who work in this space, but maybe aren't in direct admissions, are directly, at least as of now, affected by the decision, right? It still generated a lot of interest, a lot of thought, and we're working to see those all as opportunities for how we can put together something that's actually much more durable and much more specific as to who we want in our classes and who we want as graduates.
Thanks, Emily. You each come to this with a little bit of a different perspective. I think, Scott's leading institutional equity and diversity for Oregon State, Emily in the in-house counsel's office for OHSU, Penny as a outside counsel for university foundations. Do you think the lens that you view this decision from kind of shifts depending on your role?
I can go first on this one if you want. Sure. I mean, I'm always thinking like, I can't take off a defense lawyer hat in some respects. But as an in-house counsel, there is always you're making business and mission-driven decisions on a risk continuum, and so sure, I'm kind of coming at it from here are things that or maybe will keep me up a little bit at night, but will my job is to educate everyone on those legal risks, and like Penny said earlier, then recognize that there are right decisions for the institution that are not risk-free. I know our leadership has continued to lead from a place that all sorts of diversity, including racial diversity, and educating healthcare providers that can speak to healthcare and racial inequities in our healthcare system is still a top priority for us. And so we're not operating from a litigation risk-free model, but that's probably the perspective that I typically am working from. And I'm sure that Scott has a more a slightly different perspective. I think we're working to serve the same goals, and would be interested to hear how, particularly in that programmatic and people-centered place, because my role is somewhat less in that area, how you guys have been talking about it.
Yeah, I really appreciate, Emily, your mentioning kind of a risk continuum, and something that I think is really important, in particular for leaders to do. And this is something that I talk about, is that sometimes when we're talking about risk, we're not considering how we're shifting risk to different communities. So for example, if we make a decision not to pursue a particular initiative because we're concerned that there is legal risk, that's not a neutral decision. What it means is that we may be preventing opportunities for communities to access our programs. And so, and sometimes we need to make those decisions, but we cannot do so, I think, in sort of a impact neutral analysis. And I try to talk to our leaders about that, because I think it's important for us to understand, if once we see the overlay, that we consider the kind of the equity overlay. I'll share from my perspective that I've kind of bucketized the way that I've thought about this ruling. I think there are leadership conversations that need to happen, so that I think sometimes we make it an assumption that our leaders understand the four corners of this case, and I don't find that is always true. And so making sure that we're talking about this from a leadership perspective, and how what this means to me from a leadership perspective is that we actually need to double down on our goals and be extra clear about our goals, and what we're trying to do, so that we're preventing some of the harm that I think is resulting from the more popular conversation or the general narrative around this decision. And I've called on our leaders to make sure that they're actually connecting the dots, to say, here's what this ruling means, here's what it doesn't mean, but what hasn't changed is our commitment. And in fact, these are all the things that we're doing to continue moving these really important goals forward. And then in a community, the next bucket is sort of a community bucket. And I'm less concerned at that. At the programmatic level, oftentimes the conversation we're having at OSU is nothing has changed about your program. Your program primarily serves a group of students, but it is not a program that excludes anyone. Everyone is eligible for all of these student success programs. And in fact, we find that some students, because of where they grew up or their own experiences, feel more comfortable in certain spaces than others. And so making sure that those programs are accessible to all is really important. And to let them know, look, this doesn't have an impact. And what it also means is that as these program leaders are communicating with their students, they're also communicating with students. You belong here. You got here because you are a qualified student, and the success, your success is amplified by the insight and the wisdom that you bring as a result of the experiences that you've brought with you to this university. And it sounds a little, maybe that sounds, I don't know what the right word is. It should be obvious, but I don't think it is for some of our students. And in particular, in graduate spaces, where they're really thinking about, gosh, should I take someone's space or someone's spot? I think we have to acknowledge that.
Penny, anything you want to add from your perspective and lens?
I'll just quickly echo Emily, really, because my role as counsel is to inform and educate and help clients make decisions around these issues. But fundamentally, as Emily said, it really is kind of a business leadership decision around risk and the priorities of the institution. So it has been interesting, just across the spectrum, seeing how different clients have chosen different paths. So I guess that's it's been very interesting and challenging at the same time.
Really, I think that balance between, how do you minimize risk and meet institutional goals, and I think to Scott's point, provide an environment that feels supportive to a wide group of students from different backgrounds. I want to change direction a little bit, and some folks have suggested that rather than considering race and ethnicity in these university processes, a better strategy would be to focus on student and family income. So really, targeting more targeting of admissions, scholarships, whatever the university process, to students based on their income and class. So love to hear Scott, Emily, the two of you talk about that. What's your perspective on using that as a factor?
Yeah, I'll go first just briefly, and then I'd love to hear what Penny and Emily have to say. So another good thing here is that we have peer institutions that have been through this before. I'm thinking particularly about our colleagues in California, in Michigan, where race-conscious admissions were outlawed 20 plus years ago. And what we saw at the outset of those kinds of it was a proposition in California that eliminated race-conscious admissions, is that diversity dropped pretty significantly and has climbed back up as they have figured out how to structure their admission programs to focus on things like first-generation status, socioeconomic status, geographic location, et cetera. So the benefit of that is that we have a lot to learn from them as how to not repeat some of the mistakes that were made, and hopefully to minimize some of the negative impact that occurred in the wake of something like Prop 209. And so we should be talking to each other and reaching out to colleagues in California and Michigan and other states to learn from them, because I think they have a lot to offer. And I also think, at least at OSU, we've been doing a lot of this work already, because we don't again use race in our admission decisions. And so, for example, there are student support programs that are premised on first generation status and socioeconomic status. And that I think continuing to think about whether those programs are helping us achieve our goals or whether we need to tweak those strategies is important moving forward.
Yeah, thank you for that, Scott. Agree with everything you said. You know, I don't think, I think that is an important in terms of socioeconomic status and how to also provide opportunities for students to share how that has shaped them is really important, but I don't think it's a substitute. I mean, particularly in Oregon, where we're a very, very white state, and there, you know, the data out of California or Michigan, who has also had these types of restrictions embedded in their constitutional law, it does have a negative impact on the diversity of their classes. And while absolutely, I totally agree with you, there are lessons to be learned and mistakes not to make, it is not a perfect fit. And so, you know, what I would sort of, again, I'm kind of go back to, and I think, HSU is particularly able to do this because we have a more specific mission, I think. And you know, it is a health sciences, it is largely an advanced health sciences mission. But how to articulate and elicit information from applicants about their alignment with those mission factors, I think is something that needs to be done on all levels, but we are maybe better positioned to do than, you know, if you had more applicants. We're in a position to where we can give most if not all of applicants individualized holistic review. And I think it is more challenging for universities who have to have some level of screening, right? And so thinking through what levels of each of your screening process, how to remove barriers, right, from that maybe screen out racially diverse applicants. I certainly know we're evaluating our use of the MCAT, for example, in terms of having minimums, not maximums, and so to get a pool of qualified applicants, but maybe don't have some of the barriers, the structural barriers that kind of screen out a more racially diverse pool. And I know institutions, you know, where the SATs or the ACTs or things like that are also evaluating that, and that's been nationally considered. I think where you recruit from is a big piece of this, and your recruitment pool that maybe, well, and I'm going really wide. I know the subject was on socioeconomic. I think that it's just, I'm not sure that's a great substitute. I think just so many more strategies have to be considered is really my answer. Because while it's important and absolutely sort of financial experiences and for us, and financial relationship to the healthcare system is actually a really important lived experience. We would like to know about applicants. I don't think it's going to generate in Oregon any sort of close or even approximate substitute for a more for having some lived experience through race-based factors.
That's great perspective, Emily. I mean, I'm thinking a little bit more about socioeconomic status and how we expand access to higher ed. So, Scott, you'd mentioned the statewide ban on affirmative action in California. Am I right that Washington also has a ban as well? So Penny's nodding. I mean, one thing I would note about both of those states from an undergraduate perspective is they have far more robust statewide financial aid programs for undergraduates. And to the extent to which I think socioeconomics is a part of this, you know, big set of factors and picture that Emily, you're painting, I think potentially the fact that both of those states are really investing a lot more heavily than Oregon is in financial aid for low-income students does help to, provide another leg of access to the big picture of higher education equity. So, kind of a specific question, Penny, maybe for you. Speaking of other states, California, Oregon, I think there are probably some other states as well, have been offering tuition support programs specifically for members of recognized tribal nations. How does something like that impacted by the ruling, or is it? How is that different?
Yeah, so a great question. And without getting too far afield, I'll just say that Native Americans under the Supreme Court history of decisions have always been subject to a different standard. And in essence, it's because we have some decisions early on that say, so long as a person is a member of a federally recognized tribe, when we discriminate in favor of them, we are not actually discriminating like we would for any other race or ethnicity. Instead, it's sort of a citizen to citizen kind of transaction. And because Native Americans have this federal special status, they can be treated differently under the law. There was a lot of concern this last session that the court was going to dial that back with the NICWA decision. It was considering a decision around Native American adoptions. The court did not, thankfully. So we still, at least as of now, have special status for Native American students. The issue is they have to be members of a federally enrolled, they have to be enrolled members of a federally recognized tribe. And that's a hurdle for many of our Western, actually even Northeastern tribal members who faced derecognition in the kind of assimilation era of the 1950s. So there are some students in Portland who are Native American who are not enrolled and who have lost out on some of the special benefits that Oregon in particular has created for its Native American students.
Scott, did
you add just just really briefly to that? The other, in addition to everything that Penny said, especially on the West Coast, Native Hawaiians and other Pacific Islanders don't have federal recognition either, and so similarly lose out on some of the benefits that are provided to enrolled tribal members.
Those are important distinctions to draw out. Penny, you mentioned in your opening comments that you expected we would see additional legal action. Are there some things that we are already seeing? I know, for example, I think there have been some suits, another suit against Harvard around the inclusion of legacy. So in their admissions process, what can you tell us about that, or other things that you're seeing coming down the pike?
Yeah, Emily might have some insight too. They're just, we're starting to see this from basically everywhere. In fact, there was a lawsuit filed against, I think, about 3 or 4 downtown Portland law firms about their affirmative action program that they have for first-year law students. Our firm, knock on wood, runs a similar program for diverse first-year law students. We did not get named in the lawsuit, but we're filing an amicus brief on behalf of the firms that are defending against it. I think it's just an example of what we're going to start seeing more and more of. There is a case coming out of, now I'm going to get the state wrong, Virginia maybe, that is tracking this concept of substituting basically zip code for race and ethnicity. And it's a challenge to, I think it's a private school. Again, I should have looked at it before I hopped on this call, but it's essentially saying, the challenge is essentially that the school is using, or the system is using, zip codes as a substitute or a proxy for race, and therefore should be prohibited from doing that. And that, I think, is now up at the Court of Appeals, maybe the Fifth Circuit, the Seventh Circuit. Anyway, Emily, I don't know if you're probably watching that one too.
Yes, although I'm not sure I could articulate. Yeah, I haven't looked at it recently. I think you were right on everything you said in terms of right, that they've set some sort of kind of minimums from various zip codes. I think the difference is kind of the I believe they're using it as kind of quotas from zip codes as opposed, and that's a little different than sort of what we're, in using it as a in a holistic review process. But yes, agreed. I mean, there are national watch groups who are, very much watching all manner of any sort of race, inclusion of race in any forum, employment, residence, medical residencies, law firms, jobs, contracts, supplier diversity. I mean, we're so diversity programs that which we have one, prioritize or prefer contracts with women or racially owned or minority businesses. It's sort of everywhere, and I think will continue to show up in lots of different facets of university or foundational or just general life. So thinking about sort of how we're not using race or race-based proxies is a really important, is a proactive and important proactive step, I would say.
You both have mentioned the potential impacts on workforce diversity. So let's talk a little bit more about that and, really share more with us what you think the implications of the ruling are for the future of the workforce. Emily, you spoke about the importance of having a diverse healthcare workforce. We know that folks who have, experienced disparities in healthcare outcomes need to see people who look like them to feel encouraged to get the healthcare that they need. What do you think this portends for us, 10, 20 years ago as we look at the workforce of the future?
I'm happy to go first on that. So yeah, there's a lot of research that I'm certainly most familiar with it in the delivery of healthcare, right? That and we've all read it in various news articles that for example, Black pregnant mothers get better, have lower mortality rates, have better overall outcomes if they have a Black OBGYN. And there's a lot of linkage in. It's not a direct, that while all of those things are absolutely true and there's a lot of research for it, it is hard to translate that into actual when you're making employment decisions. Certainly, I think having the research is very important. Talking about it, demonstrates a need for us as a healthcare system to have a diverse range of providers to serve that mirror our patient population. And so, we talk about it in those terms. I think it's important to look at job descriptions. If part of the job is something, it is important to be able to connect with individuals of the Latinx community or an underserved community. I think it's important to call that out and focus in the employment process, right, on that is an actual essential component of the job, is that they have either the language skills or the direct experience or the community connections or the interest in connecting with this underserved community of which we are a provider. And that can be rural. I mean, we have lots of pathway programs, right, that reflect as does OSU, as does, you know, other similarly situated institutions, because we've got a diverse patient population, and that includes all kinds of diversity, and we need to be able to staff our hospital with people who serve those communities. So, you know, I think it takes the work, which is good work, of thinking through what you need, what individual employment employers and employee positions need to be able to provide the best type of service, whether that's education or you know, public interaction or healthcare. I mean, it can be a range of things, and then really work to articulate and elicit that information in a way which allows you to identify and prioritize that ability.
Thank you. Scott, what are you thinking?
Yeah, Emily's great comments have me going in all sorts of directions, but one of them are, and we're not talking about this, this could be a whole other panel, but this concept of how to write position descriptions in ways that are embedding our equity goals into the actual PD, and to do so without relying on something like a diversity statement that just says, tell me about your commitment to diversity. That's not actually helpful. And oftentimes it's not helpful because it's quite vague. I think it is in some cases rightfully viewed as kind of a litmus test. And I have a feeling we'll see a lot of challenges, and already we're seeing a lot of challenges around things like you know, diversity statements in hiring processes. And so, as the SFFA decision has asked us to think, I think, more creatively and more precisely about how we diversify our student bodies, similarly, we need to think more creatively and more precisely about how we diversify our workforces. The other thing that I'll add is that industry partners and other nonprofits end up being really important partners to educational institutions as future employers and interested sort of stakeholders in thinking about who we educate and how we develop those students and future employees. And so something that I think is wise for all of us is to think about how OSU does not have a law school, but we have lots of students that are interested in becoming lawyers, creating partnerships between leading law firms and universities to think about providing those experiences to students that might generate future lawyers that would practice at those firms. And that it's not even just at the law school, at the point of sort of a first-year law student interviewing for a summer associate position, that we're actually thinking way before that. It's like in high school, you know, because those are the kinds of pathways that will ultimately lead to, creating more diverse workforces. And I would also mention that the state is a really important partner here. There are funds available for supporting these kinds of efforts. Not only that, there's an advocacy role, I think, for all of our organizations to play in really pushing the state to think about this as a workforce development issue, that if we're actually hoping to attract the best, brightest, most talented people around the country to move to Oregon, then we need to make sure that our the doctors, the service providers, the so on and so forth actually reflect the demographic shifts that we're seeing both in Oregon and nationally.
Thank you. Well, I think there's a question in the chat that is very similar to, I think, the last question that I was planning to pose to our panelists, which is, we're lucky to have a very generous group of philanthropists who are a part of the ARCS Foundation, who are supporting OSU and OHSU. How would you all advise donors who want to support the educational success of undergraduate and graduate students who've been historically marginalized in higher ed? What should they be thinking about? How can they partner with higher education institutions to support those goals? Whoever wants to go first.
I'm happy to take an initial stab.
Right.
So, my advice would probably to be flexible in terms of that, the working with the foundation or whatever group you're working with to really articulate what you're looking to incentivize, right? And the fact is, I'm sure it's more than a box, right? Of course it's more than a box, because you are, we are making likely valid assumptions about someone's lived experience when we look at that box. And so to work to better articulate that, and what you as a donor are looking to do. The other thing is, I think some flexibility in the whole, if you look at, and this is not my area, so Scott, feel free to correct anything I say, but when you look at setting up these programs, right, it isn't just, just the financial component, huge part of it. But as Scott said, it's sort of a continuum of, like, it starts pathway programs starting at an earlier intervention place, facilitating the actual admission and the financial ability to be at an institution, and then setting up success in terms of mentorship, internal belonging, all of those things, right? There's opportunities in all of those. And so I think kind of partnering with organizations to kind of set up, each of those legs of the stool analogy isn't really a good one, because it's more of a journey, but would be helpful. I also think, institutions certainly, there's we haven't really talked about this, but kind of a pool and match piece of it. So pool and match is a scholarship kind of system where everyone in a certain pool is going to receive financial incentives. But then if there are race-based specifications or other types, gender-based specifications or something on a particular gift, they can be matched to individuals within that pool. So it isn't the actual gender, race, or other protected characteristic that's putting people in the pool. It's just sort of assigning people within a particular group. Thinking about, whether that's an option as an institution. But I would say for new donors, having some robust discussions about what really is looking to incentivize. Is it the ability to communicate, right? Either on a cultural competency or in a language, right? A fluency of Spanish? Is it what is it? Is it an ability and demonstrated commitment to serving a particular population, right? What is it that you're looking to really develop, and then working with the institution to kind of get it to that place and fulfill your intent, I think is probably what I would encourage donors to think about.
I would just add a couple points. One, I really like that idea about thinking, Emily, as you mentioned, kind of thinking about those criteria and how to develop those criteria in a way that actually get to what the donor is. I think this is one of those areas where race as a proxy has for many years been a little easier. The same way that gender has, the same way that, and what we're actually asking is for just a kind of a more nuanced, complex way of thinking about scholarshiping. I'll also mention that taking advantage of existing programs within the university is really helpful. So for example, we have 7 cultural resource centers. Those cultural resource centers are open to all students, and they tend to serve students from particular communities because their programming is focused there. So saying to a donor, you may want to create a scholarship that is intended for students that are active in this cultural resource center community, or that are taking advantage of a certain academic support program that is open to all but focuses on a particular community. It's not a perfect match, but in some ways, I think it actually can be better. Because we're actually asking for those students to be committed to their communities as well, and they're more likely then, I think, to go to stay active as engaged community members. So that's another, I think, strategy that has worked well at OSU. And I'll just share quickly on the topic of pool and match. For those of us, we don't currently use. Well, I shouldn't say that, but pool and match is a really interesting concept that I think is actually fairly low risk. And there are plenty of public institutions that are using pool and match as a strategy. It's possible that we see a challenge to it. But again, to engage general counsel in those conversations around what is it, how might we implement it? The trick of it is frankly in the implementation many times. Because it does add steps to the process, and it does also reduce control over scholarshiping processes. And so that is, but it's a really interesting model to consider.
Penny, do you have other perspectives to add to the group?
Just a quick note on pool and match. I agree. It's challenging for an undergrad institution that doesn't have a lot of unrestricted scholarship dollars for obvious reasons. So it just practically, it can be just really challenging in the race and ethnicity zone. I think just given that it's been blessed in the gender zone, we see a lot more of it there. My 2 really quick comments. One is, and Kristen, I'm saying this on behalf of you as a scholarship fundraiser, but we also want donors not to be so super hyper specific about what they're trying to fund that we're creating scholarships that never end up getting awarded. So a caution about that. The other challenge that I see, because a lot of times I'm working with donors or I'm working with private foundations that want to fund students at various universities, it's, as I said in my talk, there is a lot more flexibility if you are awarding scholarships outside of the university arena. So you can be a foundation and have your own process and award scholarships to Black students or Hispanic students and be very clear that that's what you're using your money for. That has its limitations, however, and it really doesn't support our university partners the way scholarship dollars that are awarded through the university do, because scholarship dollars awarded through the university allows the universities to really meet and sometimes exceed their DEI goals. And when you have a separate process, you're not always in alignment with the school that you're trying to support. So that's a downside for sure of the separate approach.
So Penny, just teasing that out a little bit more. I mean, and this is putting too fine a point on it, but there are scholarships, for example, where the funds are given to the private foundation, awarded by the private foundation directly to the scholarship recipients. Those are really not governed by many of the rulings that we've just talked about today. Then on the other side, you've got gifts that are given directly to the university. The university decides how to allocate those scholarships. Those are very much, under the direction of the rulings we've discussed. But then there's this sort of piece in the middle, which I think is important to, our relationship with the ARCS Foundation, where the gifts may be given to the ARCS Foundation, but there's a very deep and robust partnership with the university in the selection of those students who receive those. And it's my understanding that some of the rulings or laws that we've seen, and that sort of these issues, that because the university is involved, that these rulings do apply, or it's a lot more murky. How would you describe that?
Yeah, it's one of those gray areas and around risk and risk tolerance. So essentially, the more conservative position is the school's involvement triggers state action. So the same rules that apply that we've been talking about today apply to our ARC Scholar Awards. So I'll just leave it at that to keep it simple, but it is not black and white clear, like it's gray. But I think the more conservative approach is because of the way we partner with our universities, we are subject to these rules.
Lori, I think that got to one of the questions in the chat. Were there others that you wanted to pull up as we wrap up this afternoon?
Yes, thanks everybody. And thank you, Kristen, for moving us along. We have one question, and it isn't directed at any individual panelists, so I'll just pose it to everyone. It's from one of our board members, Ana Lucia. How do you reconcile the race-conscious prohibition in admissions with civil rights corrective action plans aimed to achieve parity with demographics?
So, well, no, Scott, I'll let you go.
No, I mean, I was just going to say, I think this is one of those examples where we're talking about two different schema, for lack of a better word, and that because of my understanding of the way that the Civil Rights Act applies to things like extension is different than in the admission realm. And at the same time, I think this is a great example of when we're having conversations with partners and they're saying, well, now we can't do some of the civil rights work that's so important to us in an extension context, that we need to have enough knowledge to say, well, let's actually talk about what the decision says and how the decision may or may not apply in this context. And that is important because I think what you're referring to, Analu, is I think the sort of the ripple effect of this SFFA. We need a better, call it something else, decision that ends up impacting other parts of the institution and our mission.
Yeah, that was a great answer. It's a great question. And it, I think, highlights how complicated this area is and how it's important to resist the urge to say, oh, we have a Supreme Court decision, therefore there can't be race preferences in anything. And that's not true. It really depends on where the law is coming from and who it affects.
Well, thank you all, Scott, Penny, Emily, for being a part of our panel today. I am going to turn it back over to Lori.
Great. Thanks to everyone who hung in there with us. This is a meaty topic that we could spend weeks and weeks on. I'm just really grateful that we have the three panelists and Kristen out there working to help us understand how we can still deliver on our mission and fulfill our commitment to equity as we move forward in some of these gray areas. So thank you all for joining us. And again, we will send a link out to the recording. If you have any other questions, please, if you don't have the panelists' email, feel free to send them to Alex or myself at ARCS Foundation, and we will connect you up with them for an answer. Again, thanks everyone for participating and taking the time to do this work, which is so important to all of us, and especially in STEM education. I hope you have a good rest of your week.
Excellent. Thank you.